Yeah, no, you know what the correct configuration is? I mean, I'm not, but do this. That's 800 by 600, so it's bigger.
Okay, if everybody could sit down, please, we're going to get started with the second panel. Okay, everybody, please sit down. We'll just keep talking until everybody's ready. Okay, I'm going to hand it over to Professor Tom Wong now.
I think I'll give it another minute while people find their seats. While we're waiting, here are my triplet boys. They're 3 years old, going on 18. And yeah, it's as hard as you might imagine. Okay, so I'm gonna go ahead and get started. Okay, so I'm going to present results from a survey of legal service providers. The question here is, well, how many undocumented youth are actually walking in the door to legal service providers asking about DACA eligibility, but walking out with potentially something better in terms of a permanent immigration benefit or a form of relief. So here we call it the mini paths to legal status. Okay, so we know that there are over 500,000 people who are now documented. Now, this number is smaller than the number of estimated young people who are currently eligible for DACA, the 1.2 million population. And we know that there's a broader 2.1 million population that will be eligible for DACA in the future. And so in the context of DACA, there have been anecdotal reports that, well, some people have gone in the door asking about DACA, but have left with something better. So the question here is, are these isolated cases, or is this a systematic trend? And if it's the latter, can we sort of put our finger on it? Can we measure it and quantify it? And if we can we get a sense of what types of immigration benefits undocumented youth are finding themselves to be eligible for? So that's the purpose of the person survey. So this owes to Don and his imagination. So potential eligibility for relief survey of nonprofits, the person survey. So here it's an online survey of legal service providers. So this is an online opt-in survey. So we can talk in the Q&A about the sort of strengths, but also the potential pitfalls of an online opt-in survey. But sort of going with what we have, we actually got over 300 clicks on the survey link. We used a snowball sampling methodology, a peer-to-peer methodology, where we're using groups like Clinic to reach out to their networks of legal service providers and encouraging them to take the survey. So we got over 300 clicks to the survey with 84 responses. So a response rate of about 25%, which is good. And of that number, 68 completed surveys. So the completion rate was high. So we're happy with that. In terms of coverage, we're talking about organizations spread across 25 states plus the District of Columbia. The organizations include established organizations and new ones. So the range here is 2 years old. We opened because of DACA to over 100 years old in service. And we have large and small organizations. We have organizations working in collaboration with other organizations to provide DACA services, but 0 paid staff, to organizations with over 100 paid staff. So in all, these organizations combined to screen 126,154 undocumented immigrants since DACA was first announced. Of this total, 30,733 were DACA-related cases. So we are sort of looking at breadcrumbs. We have this broader universe of persons who are undocumented that these legal service providers screen. We have this smaller universe of DACA cases. So then the question becomes, among these DACA cases, well, how many are in fact found to be eligible? And among this group, how many are eligible for DACA, but also something else? And this is no easy task. So one quick note, there was a lot of back and forth in the conceptualization phase of the survey. Because we are surveying legal service providers with varying degrees of capacity, the main issue here is bookkeeping. So if an organization has very good bookkeeping, then answering this survey is easier. But if an organization has sort of haphazard bookkeeping, then it is virtually impossible to isolate the number of total cases and then DACA-related cases and then the subset of individuals who are eligible for DACA but also eligible for something else. So what do we get? So here's the main takeaway. So this is the thunder here. So it's kind of anticlimactic, but there's more to show after this. All right, so walking in the door for DACA, but leaving with something better. So of the organizations that responded to the survey, 14.3% of DACA eligible persons were also found to be eligible for some other immigration benefit or form of relief. So 14.3% of young people who learn about DACA, who have the hope, have the optimism of being documented, of having a 2-year temporary legal status with 2 years of work authorization. Wow, they go into a legal service provider and they're told, wow, you're eligible for DACA, but wait, you're also eligible for something else, something that actually may put you on a path to legal permanent resident status. And we know what follows that. And so here is what this 14.3% looks like. So the broadest circle represents the total number of DACA-related cases, the 30,733 that these organizations combined to work on. And the 19,095 cases were found to be eligible, or individuals were found to be eligible for DACA. So it's this subset here, within this circle, how many are eligible for DACA, but also eligible for some other immigration benefit or form of relief? And here we see 2,727. That gives us our 14.3%. So this is not inconsequential, again, because we're talking about a 2-year temporary status to something that is potentially permanent. So the question becomes, what are these immigration benefits and forms of relief that these undocumented youth are finding themselves to be eligible for? Okay, so the many paths to legal status. And here's the alphabet soup of the immigration benefits and forms of relief. Here we see family-based visas, U visas, and SIGIS, special immigrant juvenile status. Those 3 immigration benefits and forms of relief combine to account for over 60% of this phenomenon, walking in the door for DACA, but leaving with something better. If we throw in consular processing, which is a much broader category, and adjustment, then we get 83.3% of this phenomenon. And so here is just a sort of graphical representation of it. So family-based visas are 25.5% of this phenomenon. U visas, 23.9%, SIGIS, 12.6%. So we have to qualify leaving with something better, because the better here is the LPR status and the permanence, the potential permanent immigration benefit that comes with it. But better is in quotes, because if we sort of unpack what a U visa involves, or if we unpack what a special immigrant juvenile status visa involves, and these are things that put young people through harrowing circumstances in order to get that green card. So we have this sort of top line takeaway. Of these organizations that responded to the survey, we're looking for this phenomenon, in the door for DACA, leaving with something better. And we find 14.3%, and that's a great number. That's an optimistic number. And then we unpack and we find that, well, what's driving this 14.3% are particular types of immigration benefits. Okay, so is there something about the organizations that responded to the survey that makes them more or less likely to be able to identify these young people who are eligible for DACA and potentially something better? So that's the next step. So there are a couple of things in particular to sort of focus on. The characteristics of the organizations themselves. So I mentioned that we have some established organizations and newer organizations. And I also mentioned that we have some organizations with great capacity in terms of paid staff and very little capacity in terms of few paid staff. And so this first exploration here is to see whether or not this phenomenon is explained by the characteristics of the organizations themselves. So for this particular slide, we're seeing whether or not how long an organization has been around correlates to this particular phenomenon, identifying undocumented youth who are eligible for DACA, but also something potentially better. And so here, I know this is tough to see, but there are sort of a couple of main takeaways here. One, there is not a statistically significant bivariate relationship between the number of years in operation for an organization and their ability to identify persons eligible for DACA, but also something better. So why you see a couple of different graphs here is because we can think about this phenomenon in a couple of different ways. So here, I know this axis is impossible to see, but this is the count of undocumented youth who are eligible for DACA and also eligible for something else by each organization. And so here, we see this range from 0 to about 250. So at the high end here, an organization has found about 225 undocumented youth who are eligible for DACA and something else. Okay, so we can also think about years in operation in a couple of different ways, because the simple count of the number of years in operation is so dispersed, again, from 0 to over 100. Well, we can just take the count and look at the bivariate relationship and see a flat line, no relationship. But we can also take the natural log of the number of years in operation to normalize the data and see if there's a different type of relationship that emerges. And here, we do see a positive relationship, but again, it's statistically insignificant. Now, we can also look at, instead of the count of persons who are found eligible for DACA and something else, we can look at an organization and the percentage of individuals who are found to be eligible for DACA and something else as a percentage of all of those DACA-related cases. And again, using both measures of years in operation, we see a statistically insignificant relationship. And so here, when we look at the natural log, we see positive slopes. But again, it's a statistically insignificant line. So it's not so much a function of an organization being around longer. So what might it be? So next, we look at paid staff as an indicator of capacity. And so paid staff as an indicator of capacity, no matter if we're looking at the count of individuals or the percentage of individuals, the count of paid staff or the natural log of paid staff, we see statistically significant bivariate relationships between the number of paid staff as an indicator of capacity and an organization's ability to identify this phenomenon. And I think Jeanne and some of the others on the panel will kind of attest to this finding. It makes a lot of intuitive sense. It takes people with the capacity, with the knowledge and the skill set to work on these particular cases, specifically to look for DACA eligible youth who may also be eligible for other immigration benefits in order to identify them in the first place. If an organization is running a bunch of DACA clinics screening for DACA specifically, they're not going to be able to, one, identify this phenomenon. And if that organization running DACA clinics is hamstrung in terms of the staff actually working to put those clinics together, then something like additional screening is almost impossible. So now the next question becomes, well, does this finding hold while considering some other factors? So the survey was recently closed, and here we're sort of going through an initial exploration of the determinants of this phenomenon. So not only looking at the factors of organizations, but looking at the context these organizations are working in. And so here, we see that the number of paid staff as an indicator of capacity remains significant when we look at the count of persons found to be eligible for DACA and something else. When we control for various other factors, and I know this is hard to see, but model 1 here just takes the characteristics of the organizations. So here, the natural log of years in operation, the natural log of paid staff. And if we only look at those two factors, the paid staff factor remains significant. Now, if we take some other factors into account that are perhaps germane to undocumented immigrants who may be eligible for various immigration benefits, the non-citizen population, and this would be great if we had city-level estimates of the undocumented population, the percentage of non-citizen populations that entered before 2010, so this is an indicator of duration. The percentage of non-citizen population that does not speak English very well, this is an indicator of social capital in order to access resources. And the percentage of non-citizen population below the poverty line, the SES variable. If we take these factors into account, the paid staff variable remains significant. What's interesting is that none of these other factors come up significant, and that's unexpected, and I don't fully trust that these factors are in fact insignificant to this phenomenon. But again, this is a first cut. So the count of individuals who are found to be eligible for DACA and something else can be explained by paid staff, or is at least correlated by paid staff. So the characteristic of the organization matters. Now, when we move to the percentage of individuals who are found to be eligible for other immigration benefits as a percentage of all DACA-related cases, I know that's a mouthful, for each of the organizations, well, that's just another way to cut our dependent variable, another way to look at this phenomenon. And here what we see is that, well, paid staff is inconsistently significant. So if we just look at years in operation and paid staff, we still see that paid staff is significant. But when we take into account these other factors, again, SES for non-citizens, social capital for non-citizens, like the time in the US for non-citizens, then the significance of the paid staff variable fades. Okay, so we know that this phenomenon is occurring at about 14.3% for the organizations that responded to the survey, that a handful of immigration benefits are driving this phenomenon. Paid staff as an indicator of capacity seems to be a significant factor at the organizational level to identify this phenomenon. And so here we sort of conclude by saying, well, is there something different about the DACA eligible population from the broader undocumented population? So in other words, should legal service providers or those doing DACA workshops and clinics be focusing on the same things that are germane and relevant for the broader undocumented population, or should they specialize in something else? And the answer seems to be specializing in something else. So here on the left axis, we're talking about the percentage of this phenomenon by the main immigration benefits. So again, family-based visas, U visas, SIGIS. And in here, on the right axis, we're talking about the percentage of individuals who fit into these categories for the broader undocumented population that legal service providers work with. So here, think about DACA-related cases, non-DACA-related cases, and how the two differ in terms of the breakdown in immigration benefits and forms of relief. So here, the most striking difference is 2.5 times more likely to involve U visas. So again, for this phenomenon, walking in the door for DACA, leaving for something better, 2.5 times more likely to involve U visas than the broader undocumented population that legal service providers work with. 2.4 times more likely to involve SIGIS. 1.5 times more likely to involve family-based visas, and so on. So this just kind of helps us see it a little better. So here's one of the main sort of differences. For the DACA phenomenon, we're talking about 25.5% of DACA-related cases that are found to be eligible for some other immigration benefit or form of relief, being this yellow line, which is U visa. Now, here, for the broader undocumented population that legal service providers work with, U visas only make up about 10% of their caseload. So 14.3%, about 5 immigration benefits and forms of relief make up this phenomenon. paid staff as an indicator of capacity seems to be an important predictor. And there are differences in the types of immigration benefits and forms of relief that legal service providers and those who are working on DACA clinics and workshops may want to focus on relative to the broader undocumented population. And that's kind of the conclusion. 14.3%, that's the phenomenon. 83.3% is family-based visas, U visas, SIGIS, consular processing and adjustment, paid staff here. So what does this mean? What can this potentially point to? Well, those with the capacity to screen beyond DACA should, right? So legal service providers who are providing services to the DACA eligible population should, in fact, screen for a broader range of immigration benefits and forms of relief. But then there's this other group of community-based organizations that may not have legal expertise, but have their hearts in the right place, that they want to provide information about DACA. They partner with different community-based organizations that may have legal expertise, or partner with individual lawyers who work on immigration to provide services. Now, for this group of organizations, it's going to be important to expand the range of partnerships to find those with legal expertise, again, maybe focusing on family-based visas, U visas, and SIGIS, because that is, again, over 60% of this phenomenon. So I'll end there and pass it over to Jeanne Atkinson. So. And is it on? Hello. Okay. So I also have the pleasure of introducing Jeanne Atkinson, who's the Executive Director of the Catholic Legal Immigration Network, Inc. Clinic. So prior to joining Clinic, Ms. Atkinson served as the Director of the Catholic Charities Immigration Legal Services for the Archdiocese of Washington, where she led the active and successful legal services program, as well as the Catholic Charities Refugee Center. Suffice it to say, Jeanne Atkinson is incredibly accomplished and distinguished, and I will turn the mic over to her.
Great, thank you very much. Thank you very much. I am delighted to be here. As Don said at the beginning this morning, anecdotally, we've been hearing that DACA applicants had come in and were eligible for other forms of relief. And extrapolating Tom's findings, which half of you in this room can tell me we shouldn't do it this way, but if you look at the 11 million and 14%, we're talking more than 1.5 million people potentially eligible for some other form of relief. Again, that's probably not the way we can do it, but we do know that it is a very large number, and we know it's a very important number. And again, Tom mentioned this, but the ramifications of applying for DACA and accepting that as your benefit when you have potentially another benefit that may be better for you could mean you have longer waits to getting permanent residence and citizenship, separation from family that may be unnecessary, as well as deportation. So I think the question raised in the survey is, how do immigration legal service providers at the community level respond to these findings, and how do we at Clinic work with our affiliates on these findings? Is this an argument for a large-scale screening program of the unauthorized population? If we make the argument, do we stand a chance of getting others to buy in? Because that would be a not inexpensive proposition. I think at a minimum, we should be looking at better outreach and education to the general population, as well as screening and then again education of unauthorized immigrants that we currently touch in some fashion. Now that might be through DACA, it might be administrative relief when that comes, other immigration assistance we're providing, but it could also be in other areas that we are touching the immigrant community and the unauthorized community. And that may be in connection with driver's licenses, Affordable Care Act for mixed status families, ESL classes, and numerous other places and opportunities where we do work with unauthorized individuals. So there are several takeaways. or things that we need to be considering. And again, some of these have been stated and some of these are very obvious, but this is how we, I think, will be thinking as we move forward. High quality screening is vital. Many of us who've done legal services to clients would say that that initial screening is the hardest part of many cases, because you do have to know when you're talking to someone whether they're eligible for an H-1B professional visa, which we do get at our local community-based and faith-based programs, or DACA, or a family-based petition. So one issue will be raising awareness of that need for screening with the results of this study. It also means that we need good screening tools, and some of those can help in the settings that Tom was speaking about with perhaps less sophisticated programs. Partnerships will be key. Screening tools, including some internet-based screening tools that are high quality, will also be, I think, invaluable. Another clear issue through this research is that legal training does need to take place. So if those three types of relief, the U visas, family-based, and SIJS, the special immigrant juvenile status, account for the majority of the relief available, we have work to do. So Clinic conducts a survey every year of its affiliates. Right now we have about 266, I believe. And we found that 92% of our affiliates do family-based immigration law. 68% of them do U visas and Violence Against Women Act cases. So that's already a much smaller number. 32% only do special immigrant juvenile status. Now, it doesn't mean that they need to be doing these types of cases, and many of them do what they do for a very specific reason. But they do need to know the eligibility requirements so that they can do that type of a thorough screening. I think we need outreach and communication on this. People in the immigrant community, and of course those serving immigrant communities, need to know that there are these possibilities out there. We don't want to miss the self-filers who are doing applications on their own and may apply for DACA or administrative relief without considering that there may be something else out there. To the extent we can, we would like to raise awareness, I think, of just an immigration checkup. If there's a way to educate the community that, like a medical checkup, sometimes you just go in to see if there is anything available for you. One of the challenges there is that we know with DACA, the cost of DACA has prohibited some people from applying. And so in normal practice, you see that in other cases where someone will come in clearly eligible for an option, you ask them why they didn't come earlier, and quite often, at least in our nonprofit communities, it is money. So now this challenge of getting people to come in when they don't know they're eligible for something is work that we will have to do. And I think, to me, it emphasizes a few things. The need for low-cost services, so that we're minimizing that barrier to the extent we can. I think it talks also of using workshop models to the extent that they can be effective for people and lower cost. And then I would say, finally, we want to take into account that circumstances change for people. So someone can be a victim of a crime at any time. If they weren't eligible for the U visa yesterday, tomorrow they are. Family status changes all the time as well. So it's this notion that this isn't kind of an immutable characteristic. It will change, and we need to be thinking about that as well. So again, I think it speaks to looking at the immigration legal services programs and making sure that the ones we're building are sustainable. People get trust, they build a relationship of trust with their community service providers and are likely, or more likely, I think, to go back again and kind of check in periodically when they have a question. It also suggests that periodic checkup as being of value. So as I started off saying, these findings are incredibly important. They're very exciting. I think we'll take this information and we'll be working on it and kind of chewing on it a very long time. It will definitely be valuable in how we serve the immigrant community today, but also as we're planning for administrative relief, which we hope will someday come, and more broadly, how we should be using these findings. Thank you.
So next we have Maria Caba, Director of Operations and Outreach at Atlas DIY, an incubator for education, empowerment, and community for unauthorized youth and their allies. And Maria has a sort of personal story to share that is relevant to the findings here.
Good morning, everyone. Good morning, everyone.
Good morning.
So this report that Tom did, I feel like you should add one because I'm included there. I came to the United States when I was 2 years old. I was born in Dominican Republic, San Jose de la Mata. My parents decided that they wanted to come to this country. Unfortunately, I came undocumented, but at 2 years old, you don't know you're undocumented. And so for 24 years, I called the New York City my home, the New York City area. And my childhood was very normal. I saw the Yankees play against the Mets. By the way, go Yankees. I went to Coney Island and I rode the Cyclone. I went to school and I participated in activities. I was in the JRTC for the Marine Corps. I wanted to join the military. I wanted to work for the FBI. I had so many dreams. It wasn't until my sophomore year of high school that I realized that I was undocumented. And so growing up, it was spoken about that I had something that I didn't have something. I wasn't normal. But for some reason, I convinced myself that my mom had misplaced whatever it was that I was missing. I don't know why I convinced myself that, but that's what I truly believed. And so sophomore year of high school, I went into my high school to donate blood, and they gave me a form where they asked for my social security number. And I never once had been asked that. And I was like, well, I don't know what this number is. And they were like, well, go inside the main office and they have it on file. And I'm like, okay, they have it on file. So I go inside the main office and I'm like, I'm looking for my social security number. They said you have it on file. And so sure enough, they open the file and it's not there. And I'm like, well, it must be there. And so in New York State, you have a school ID number, which so happens to be 9 digits. And so they convinced me, oh, they put your social security number in a different place. So this is your social security number. And I was like, okay. And then I later on in the evening, I went home and I spoke with my aunt and I was like, you know, today at school, they asked me for this and the main office says that this was my number, but I'm not really sure. Can you explain this to me? And so that's when I realized that sure enough, it wasn't something that was lost. It wasn't something that I can easily find. It wasn't something that I can just walk into an office and say, hey, can I get this number? I was undocumented. And so for the next couple of years, you know, my life went from being really, really happy because you're still a child, you're unaware, to just, you know, feeling very unhappy, feeling like you don't belong, a sense of like just not being wanted, although you've lived in the country for so many years that it's your home, right? This is where your family and your friends are. But on June 15th, when Obama announced DACA, I was extremely happy, extremely elated. I obviously qualify 100%, or I meet all the requirements. And so I started doing research so I can apply for DACA. But the amount of fees that lawyers were paying, were asking to be paid, was insane, and I wasn't able to afford that. So I decided to do it pro se, which Jeanne just said, what she said earlier, it kind of hit me then and there. If I had done it pro se, then, well, you'll hear the end of the story. You'll realize my story wouldn't end the way it ended now. And so I went on YouTube and I found a lady that was so lively and she was bubbly and she was a lawyer and she was so funny and so nice. And I realized that she was in New York, and she said, you know, if you want to apply for DACA, you can come get a quick check. And I'm like, okay. So I filled out my application. I went into her office. Her name is Lauren Burke. She's the co-founder and executive director of Atlas DIY. And so while sitting in her office, once again, another question that I don't know how to answer. I'm being asked for my A number. I'm like, well, I don't know exactly what that is. And then, so she sat me down, and although this was supposed to be a quick check, just looking through my application, she just sat down and she started asking me questions. She was like, well, when did you come? You know, and she started asking me questions, and some of the questions I just didn't know the answer to, because my family they just kept it away from me for so long. And so we both decided that it would be best for me to go ahead and apply for DACA while I figured out the questions I didn't know. And so I requested a Freedom of Information Act, where Lauren was able to look at my records and see that my mom petitioned for me in 1994. And because of complications, I wasn't able to adjust sooner. And so nevertheless, I put in my application for DACA on March 2013. November 2013, I got approved for DACA. And then in December, I started working towards my family-based petition. And so in in March 2014, I submitted my adjustment of status application. And recently, September 19th, I walked into the USCIS Service Center in Long Island City as a documented recipient, and I walked out as a legal permanent resident of the United States. And thank you. Thank you. And I really just want to thank CMS for inviting me today to share my story and to just draw the light of the importance of screening for something more permanent, because although DACA is amazing and it definitely gives these young people more opportunity, it is only temporary. And let's be honest, DACA is here today, but we don't know if it will be here in 2 years from now. And so ultimately we have to think long term. And this is something, like, obviously Tom's finding, it shows it's not something that only a few, like, very little people experience. This is something that you see throughout. I have many friends who have applied for DACA. I have one friend in particular who actually put her DACA petition before she put in her U visa petition, and her U visa petition came through before her DACA did. And I have a friend who qualified for VAWA, and the same thing for her. And so this is something that is extremely important. And if there's any lawyers here, I really, really strongly, urge you to just ask questions, spend a few extra minutes and just ask these questions, because this can truly change a young person's life. Thank you so much.
So next we have Juan Osuna. So Juan Osuna was appointed as the Director of the Executive Office for Immigration Review in May 2011. He served as Acting Director from December 2010 to May 2011. He has a BA from George Washington, a law degree from Washington College of Law, American University, and an MA in Law and International Affairs from the School of International Service at America.
Thank you, Tom. Thank you to CMS, Don Corona, and others for inviting me, and thank you for holding this important forum. So what I'm going to do is just briefly talk about kind of the view from the immigration court system about the issues that were raised by Tom's research and some of the other comments. And I think that, while a lot of DACA applicants obviously walked into the USCIS doors to apply, or walked into lawyers' offices or legal service providers' offices to see if they were eligible, what we see at the immigration court is kind of a small portion of that, which is what happens if somebody finds themselves in removal proceedings, before an immigration judge, who then appears to be eligible for DACA or for some other sort of relief. Now, let me just say initially that when DACA was announced a couple of years ago, we actually saw very, very few cases of pure DACA cases in immigration courts around the country. I would say there were mostly, probably in the hundreds, if not the low thousands, in terms of the people that actually appear to be purely DACA eligible. But that's not, of course, what the end of the question here, because the question is, what else may somebody be eligible for? And it is a phenomenon that happens fairly often before immigration judges, because of the number of programs that are out there, the complicated law, the complicated set of regulations that may render somebody eligible for some sort of relief from removal. And when judges are confronted with that situation, they somewhat can do a little bit, but then they really have some limited tools at their disposal. They can ask questions. They can ask, a non-citizen respondent before them, about their circumstances, and that may raise some questions in the judge's mind. Excuse me, in the judge's mind, that somebody is eligible for some sort of relief from removal that they may qualify for. And the judge may do something like, for example, grant a continuance for somebody to get a lawyer, to take more time to see what's they're eligible for. And many of judges, of course, do that. But then what happens? Then there is no, as many of you know, as most of you probably know by now, there is no right to counsel, right to appointed counsel in immigration proceedings. These are civil proceedings, they're not criminal proceedings, so there's no Sixth Amendment right to counsel, which means that the judges and the courts have to rely on the legal community to step up and represent people in immigration court. And that's where the challenge that is presented by the issues that are raised here is really kind of a microcosm of what the reality of the immigration court system is, writ large, which is the absence or the lack of adequate legal services for the tens of thousands of people that go through immigration court every year. And I should note, again, as many of you know, having had these discussions for a while, that good representation is not only good for the people that appear before the court, but it's also good for the court themselves, because most judges will tell you that they would much rather have a well-represented person before them, rather than trying to tease out this very complicated set of laws with somebody who may be unrepresented, who has language barriers, who has all the barriers that judges see in immigration court every year, every day. So a couple of comments about the what happens if a judge does find himself with somebody who is unrepresented. Luckily, I think that you are actually quite lucky in New York City, because New York has done so much. The legal community here has done so much to try to encourage legal representation, pro bono representation, and other types of legal representation. The city council has done some things, as you know, to try to encourage organizations and lawyers to step forward. But that's really not the case nationwide. In fact, in some parts of the country, it's really quite the opposite. Now, I will say that legal representation, since I've been around, has actually gotten better. When I first started doing these cases years ago, it was, I think the numbers were about 35 to 40% of people in removal proceedings nationwide had lawyers, meaning that well over half, 65% or more, 65% had to appear before judges alone, pro se. Those numbers have been flipped now in the many years that I've been doing this, and now the number is closer to 65% or 60% overall do have lawyers appearing before immigration judges. The numbers in detained locations are much lower. Unfortunately, only about 25% of people in detention while waiting their hearing before a judge have lawyers or have legal representation. In non-detained locations, they're quite a bit higher, 70, 75%. But overall, it is a trend that has gotten better over the years, again, thanks to the efforts of people in government and outside of government. The issue, though, is that still remains is the quality of representation. And this is, I think, the nugget of what Tom's research was getting at, that unfortunately, more people do have legal representation, but it's not necessarily good representation. And so when somebody appears in immigration court with it, before a judge, say to apply for, let's say asylum, it is unfortunately, I think, still the case that it's rare that the legal representative, the lawyer, will have done the due diligence to see what else the person might be eligible for, whether there's a family visa available, a U visa, or something like that, or in the case of a child, special immigrant juvenile status. And that's unfortunately something that does continue. So we sometimes have a situation where the judge will make a ruling, the person will then have a removal order, and then before the removal order is executed, then the person does find himself a good lawyer. Maybe they find themselves Karen Grise over here, and Karen determines that they are eligible for 3 or 4 other forms of relief, and therefore a motion is filed to reopen the case. Now that's fine, but then you see, we've just created inefficiencies in the court system, because the case that should have been over with if somebody had a good lawyer from the beginning, because they've got some sort of relief available, now results in a delay of a couple of years, a motion to reopen, and now that judge had to issue, has to look at the case twice or 3 or 4 times. So that's why the importance of good lawyering and good legal representation remains just a critical thing. A couple of things, and then we'll open it up for discussion of what we're trying to do to make things a little bit better, which is, while there is no right to government paid counsel, we have found a little bit of an exception for certain populations that are here in immigration court, vulnerable populations we call them. So we do have programs right now, small programs, but at least there's something for people who are mentally incompetent, and through our what we call our Justice AmeriCorps program for unaccompanied children. In those situations, the government has committed to paying for lawyers in small programs, but paying for lawyers for those individuals that appear before immigration judges, and we'll see where that goes. But those programs are quite promising and have already shown, significant benefits. In addition, there are new regulations that will be coming, hopefully very soon. I know some of you have been hearing me say this for about 3 or 4 years now, that they're coming very soon, but this time I promise you they're coming very soon, which we call the Recognition and Accreditation Program, which is regulations designed to encourage non-lawyers, but that are fully accredited and fully qualified to step up and represent immigrants in removal proceedings. And I'm very hopeful finally that we will see those regulations by the end of the year. A couple of weeks ago, we published a couple of sets of regulations that are also it's designed to make it easier for legal service providers to step up and provide representation. And we'll see where all this goes. Now all this is all good, and again, New York City, I think, is quite lucky in that there's a lot of programs out here, but it's not adequate still. I mean, unfortunately, the numbers are such, and the numbers, especially as a result of the recent border situation, that has resulted in a lot of new cases coming to the courts and throughout the immigration agencies. The reality, unfortunately, is that there's just not enough help out there for people and for these cases that really need the assistance. So we'll kind of muddle along as best we can, but I do just want to leave you with that thought that while there is some very good news to report over the last few years in terms of the positive trends toward representation, we still see, and there's still a need to do exactly what this research has pointed, which is don't just assume that somebody's eligible for one form of relief. The good lawyers, the good representatives, do the digging, ask the questions, and prepare somebody for something else that they may not have been eligible for at the beginning. And that's useful not just for the person, but again for the court system as well. So let me leave it there, and then we can have the discussion.
Hi, my name is Matthew Burnett. I'm the director of the Immigration Advocates Network, and we're a network of nonprofit immigration advocates, and we provide training, technical assistance, and also some consumer-facing tools like Pocket.co, a mobile app. I'm very interested in this issue of capacity, and thanks for all your work on this issue. One of the things I was interested in, if you looked at other variables beyond the length of time a program has been around and paid staff, things like whether number of attorneys or BIA reps, whether programs geographic location matters, rural versus urban, the types of legal services they're providing, as well as the complexity of legal services, and whether you gleaned anything from that.
Yeah, well, thank you for the question. We tried to make this survey as short as possible because we were really concerned that the organizations who saw the survey link would be scared away from taking it because they may not have the sort of bookkeeping in place to answer the questions. And so the survey as a whole consisted of about 10 questions in all. And so we have the number of years in operation, we have number of paid staff, we have the geography of the organization, so we can look at some contextual factors, but we can't really dig deeper past that. And that's a limitation of the survey, but that was a sort of damned if you do, damned if you don't type of thing. We want to get people to respond, and so we want to make the survey easy to take. So next steps, right? So next step is to actually sort of dig deep with a sort of varying range of organizations who vary in terms of capacity, vary in terms of those characteristics that you mentioned, and do some qualitative digging to see whether or not it is a sort of programmatic issue that sort of leads to this phenomenon, or whether or not it is as simple as partnering with community-based organizations who may have legal expertise on an issue to increase the number of individuals found to be eligible. But there are many more steps to this, and I sort of consider this as a sort of first draft. So the qualitative aspect, I think, is going to be important, but a follow-up version of the survey is something that I hope to do before we actually sort of move to writing up the survey results and sort of finalizing it. And I'll sort of discuss that when I think somebody will mention that an opt-in online survey is a bunch of rubbish.
So one suggestion which I can follow up with you on is we maintain a national directory of about 1,000 legal service providers, which does collect some of those data points, number of attorneys, the types of services, and things like that. So there may be a way that we can sort of cross-tabulate with that data and figure out whether some of those variables exist.
Yeah, without monopolizing time. So we know that through GuideStar, there are over 4,000 nonprofit organizations with this P84 tag, which is to serve ethnic and immigrant communities. And so potentially a low-cost next cut is to actually take that as a universe and then randomly select from that universe and send out the survey link. And so if we have these broader lists, right, so you mentioned this 1,000, then we can begin to more systematically implement the survey. So yes, I would love to talk to you after this.
Thank you so much. My name is Eve Scotland. I'm the director of the Doors Legal Services Center, which is a local service provider. We represent many undocumented youth in DACA and many other issues. And Professor Wong, I wanted to thank you for your research, which in many ways mirrors what we've seen anecdotally at our agency, although I would say probably the number of young people that come in seeking DACA and are eligible for something beyond DACA is higher than 14% at our office, which may have to do with a local characteristic, which is that in New York State, young people are eligible for special immigrant juvenile status until 21 instead of 18. So that may be just a local phenomenon. But I see in your research and really in all of the speakers' remarks a cautionary tale, potential cautionary tale for a broader form of administrative relief. I've become somewhat jaded at this point about whether or not a broader form of administrative relief will happen. But if it does, I think there's a cautionary tale here about putting all of our, chickens in one basket, eggs in the administrative relief basket. So DACA is in fact a much smaller form of administrative relief, and a lot of eggs were put in that basket. And in that process, perhaps we overlooked many very robust forms of relief that had existed for years and were underutilized. Why were these forms of relief underutilized? Well, they were underutilized because of, as Mr. Osuna said, there's not adequate legal counsel, right? People can't find attorneys. They can't find attorneys either for a price they can afford or for a price that they can afford and the attorney is not competent, or if they need free legal services and they can't find it, they're not going to apply, especially a younger population perhaps, for asylum, U visas, T visas, special immigrant juvenile status. These are very difficult remedies for people to access on their own. So I want to make sure that we don't do what we did with DACA and overlook, perhaps, and get excited by a new remedy and overlook the very real, long-standing lack of access to existing remedies, and perhaps, again, to existing superior remedies. We want everybody to get access to whatever they can get access to, but do we want them to get access to DACA or to administrative relief instead of asylum, U visa, family-based adjustment? No, we want, as attorneys, as advocates, we want people to, as people who care about the law, we worked hard to get these laws in place. Each one of them was a triumph. That VAWA exists, for example, that U visas exist. We want to make sure people have access to the best remedy that our law provides. So if you could speak to that, if you agree or disagree, I'd be very grateful.
Well, I'll speak to the first part, and I think maybe some other panelists can speak to the latter half of your comments. I need to sort of give credit where credit is due. I may have just kind of, looked at the numbers and threw up these, bivariate scatter plots. But the work really owes to Dawn and Jeanne and Mary McCarthy, if she's here, because in terms of getting this survey put together, asking the right questions, it was a long iterative process, and hopefully we did an okay job. And in order to get sort of responses to the survey, it really owes to their existing networks. And it would be great if, in the second round of the survey, if your organization could take the survey. So yeah, we have seen a large range of that percentage of cases, right? So that's the percentage of individuals found eligible for something else based on all the DACA-related cases. So the high is about 75% of an organization's cases. And so the low, though, lots of organizations, it was a fat zero, right? So we asked a question first about whether or not the organization screened for other immigration benefits and forms of relief. And so even those that said yes, there are some who had a big goose egg. And so there is this wide variation. And so this is the empirical question that I'm sort of interested in as a social scientist. What explains that variation? And so one working hypothesis is that the organizational characteristics matter. And then another is these sort of contextual factors related to the undocumented population in a place also matters. So hopefully as this research matures, we'll be able to come up with better answers.
I would just say, Eve, you're absolutely right. And I think what Tom found with the issue of paid staff being significant speaks to breadth and depth of knowledge, and the fact that hopefully the majority of those staff are doing these deeper, longer interviews that Maria mentioned in her own case. So that is exactly what needs to happen. And this is just one more tool to get that word out.
Hi, my name is John Mollenkoff, and my question is, what are the implications of your work for what state, local, and even federal government, and also philanthropy should be doing to strengthen work in this area? And should we ever get comprehensive immigration reform planned for, sort of a much larger workload that would follow from that?
Let me just kick it off and then turn it over to the others. I think that I think when it comes to legal services and provision of counsel, it's really important to keep stressing the point that you're not just talking about enhancing and protecting due process for individuals that are appearing before court. You're also talking about making the system more efficient, and that's something that we try to stress over and over again when we deal with policymakers on the Hill, for example, that these types of programs actually make the system more efficient and function more smoothly. Most immigration judges, confronted with somebody who appears to be eligible for something but cannot articulate it, going to continue the case and give people more time and all that. That's fine, and that's the thing to do. But you're creating inefficiencies that way. So the model that we've seen with for example, the legal orientation program, which some of you may know is a program that we have to provide know your rights and other types of programs in detention facilities primarily, has clearly shown that not only is it benefiting the individuals that are appearing in court, but it's also just cutting down detention times, cutting down costs in detention, making things more smoothly. So I think with any of these initiatives, any of these ideas about legal representation and the need for it, it's really critical to make the case for a more sustainable program that it's not just about due process, it's also about efficiencies and making the entire system function a little bit more smoothly.
I would just add that what we need to do is build capacity, and it's a wide variety of actors, which would include the local government and other parties. So these different entities have different roles that they can play, and they're all very valuable in ensuring that we are reaching out to particularly harder to reach immigrant populations. But we're working with libraries, domestic violence shelters, local governments. It's no longer just kind of legal service programs. It's a number of people working together, and that includes, I think, the philanthropic sector.
And I'll just add, I've I've kind of voiced an unpopular opinion when it comes to what the philanthropic sector can do with respect to DACA. So there's this sort of, effort to reach out to the eligible but not yet applied population. And so the question is, well, how do we reach that particular population in order to get them to apply? Well, that assumes that this population who is eligible actually wants to apply. And so I have to remind some funders that, well, DACA sometimes may not make sense for an individual. So here's an example. Somebody may be working, using a borrowed Social Security card, is happy with their job, has a good relationship with their employer. And what does DACA require that person to do? Tell that employer, ooh, you know what? My name isn't Tom, it's Jeanne. And I'm undocumented, and the Social Security card that I've used, well, it's not actually mine. And so that may be very disruptive for an individual. And the education requirement also may be disruptive for an individual. And so efforts to continue outreach to identify those eligible but not yet applied DACA young people, that's great, and that should be continued, but maybe we frame it differently, because if this population knows that they're eligible but hasn't yet applied, we don't want to force applying on them, but we can change the cost-benefit dynamic to say, well, DACA is just one possibility out of many. And so the unpopular opinion that I've been voicing is that there may be diminishing returns to the existing outreach template that has been used for DACA, and that we need to expand the framing of this outreach to broader immigration benefits and potential relief.
Hi, my name is Vanna Slaughter, and I'm with Catholic Charities Immigration and Legal Services in Dallas, Texas. And hearkening back to the comment about superior relief, I think we would all in the room agree that there is no superior relief to that of being a citizen. And in our DACA work, we identified 2 DACA consultations to be. One was an acquired citizen, the other was a derivative citizen. Since none of you mentioned that form of relief, I know that's few, they're few and far between, but let's not forget about good old citizenship. And Director Osuna, we just had an even sweeter moment in the immigration court last week when we accompanied a 13-year-old unaccompanied minor from Honduras and refused to plead to the first allegation that she was not a citizen of the United States, because we believe she is, and we've already filed the N-600, and I believe we're going to prevail on that because she already has a brother who has done the process. So let's not forget citizenship.
Yeah, just a quick note. So for the purposes of making these figures legible for the presentation, I just focused on those 5 main categories. The actual survey also includes derivative citizenship, and that phenomenon is less than 1%. So it's small, but it's there, and I totally agree, it's incredibly important. So other categories also include VAWA, employment-based visas, which was a tiny fraction, T visas, which was almost 0. So the menu of different immigration benefits and forms of relief in the survey are much wider, but I just kind of summarized.
If I can just make a quick point, it's not too surprising to me that Vanna Slaughter got that kind of result, because this is the type of work that she's done for many years, and that kind of credibility that she has. And I would just note that many of you in the room are, with organizations that have that kind of credibility with immigration judges. So when a clinic comes in, or Catholic Charities comes in and makes the point, hey, this child might actually be a U.S. citizen, and here it is. That those organizations are listened to. So thank you for all your work.
I'm Atkinson. I'm with Warner Constant Family Fund. We're part of that dialogue and philanthropy that you're talking about. And I really appreciate your comments about outreach and needing to be redesigned. I just wanted to urge you all to consider that even more importantly than redesigning outreach is the need to redesign the kinds of services that are available to applicants, because I think your point's correct that many don't apply because it's not convenient, but we know there are many others, particularly rural areas, who don't apply because they don't have the kind of ongoing coaching support that is needed to help them through this tough process of getting through meeting the educational requirements, for the older ones getting through the continuous residence documentation, etc. And so I think our position in that debate continues to be, well, let's look more broadly than it's screening to what are we going to do by way of ongoing support services.
Well, thank you for that comment. I'll just say one thing. When DACA was first began, I was fortunate to get some FOIA data from USCIS that was geocoded at the zip code level. We later learned that that was a mistake on the part of USCIS and organizations and others who have sought geocoded, individual level DACA data at the zip code level have proven unsuccessful, and myself, I have also been proven unsuccessful. But they sent me the first batch, and I have used it, and I have shared it with a lot of organizations, some here and around the country, to micro-target at the sort of city level, the MSA level, et cetera, where to potentially target services, including during the first wave of the renewal process. And in the first 150 or so thousand applications submitted, I tabbed all of the data up by rural areas using census definitions and found that less than 1% of those initial applications came from rural areas. And so that is definitely something that shows up in the data as an area of need. I don't know what has been done, though, that has been effective to close that gap. And so more work is needed.
I'm Karen Grisay from Washington, D.C., and I have two quick clarifications for Tom on the research and then one question for Director Osuna if we have time. On the research, you talked about the big universe of people who came in the door looking for DACA, and then those who were found to be eligible for something else as well. And I wondered whether anywhere in the research it looks at those people who came in looking for DACA who weren't eligible for DACA but may have been screened and found to be eligible for something else instead rather than as well. That's one.
Yeah, so quick answer, yes. So we actually asked that question, and we forced responses for most of the questions in the survey, but we let this question go because some organizations, especially those sort of collaborative community-based organizations who are running one-off DACA clinics and workshops, they might not have the capacity to follow up with folks. So this particular question of found not to be eligible for DACA, but found to be eligible for some other immigration benefit or form of relief, that is in the survey. It's only a handful of organizations, though, and these are usually the longer tenured and larger ones who gave those responses. And so we actually have those responses from those organizations, as well as a similar breakdown in terms of immigration benefits and forms of relief. There just aren't very many organizations to talk about there. But yeah, that phenomenon does exist and we've captured it, but there's a selection effect of those organizations that have the capacity to keep that level of detail.
Thank you. And I want to understand when you talked about the numbers where people were eligible for SIJS or for a family-based petition and then adjustment. Does that adjustment means cases like Maria where nobody had to file a petition, they were ready to adjust immediately, versus the SIJS and the U or whatever where ultimately an adjustment is also required? Is that the distinction?
Yeah, so we forced response SIJS because we're interested in that. We forced response the broad category of family-based visas, but then we left consular processing as other and then adjustment as other. So you could say if you had a case that was SIJS, you can say it specifically. But if you had another case that was related to adjustment but not SIJS, then you can just put adjustment.
Oh, so they could be blurred, actually.
No, they can't be blurred. So the forced responses equal 100%. So there might be some overlap, right? So that definitely is possible. But there are forms of adjustment that don't involve SIJS. There are forms of consular processing that don't involve the family-based petition, for example. But we wanted to weed these particular categories out from the broader categories of consular processing and adjustment.
I see. Okay. Yeah. And for Director Osuna, you mentioned the small programs for appointed counsel for juveniles and mentally incompetent. And I know that Attorney General Holder was personally very committed to both of those. And I wonder if you can say now with the Attorney General transition, and you may not be able to, how much are those entrenched support for those in the DOJ or under this administration as a whole without Mr. Holder's leadership?
Thank you, Karen. There is wide support for those programs within not only the Department of Justice, but also within the administration, including all the way up to the White House. The administration itself is not the issue with those. I do get a little bit nervous about Congress on those programs because, let's face it, at least a significant part of the U.S. Congress is not real wild and crazy about, giving lawyers to aliens, type of thing. Especially, illegal aliens. That's just that's just the reality. Which is why, again, the broken record, but I think we need to stress within government and outside of government that when you're talking about legal service programs, appointed counsel programs, it is not just a matter of due process for immigrants. It is also a matter of court and administrative efficiencies and effectiveness because I do get a little bit nervous about, especially with the visibility that the system is under right now because of the border situation, that programs like that could become a target, especially in the House of Representatives.
So we are actually running out of time. So if we can take your question, but maybe answer it while everybody goes off to lunch. Well, you can go ahead and ask your question, and we'll answer it. Whoever's
it's more a personal story of immigration in the U.S. I'll do it quickly. Immigration in the U.S. is another story of U.S. hypocrisy. When my grandfather came here 100 years ago, my name is Robert Bucks. I'm a professor at University of Pisa in Italy. 100 years ago, in order to exploit him from southern Italy, they had to physically bring him here. Now that we have the technology, why allow these poor, ignorant, uneducated, needy people to come to the land of the dream when we can simply go there to Honduras or Vietnam and exploit them there? It's far more convenient. Don't have to deal with unions, don't have to deal with minimum wage, can exploit child labor. It's another story of the hypocrisy of the American dream. The American dream. It's hypocrisy. To go through all of this about people in need, and the borders are closed.
So I think we'll chew on that over lunch.